Assalamu alaikum. Have a good day. Welcome to Financial Management eLearning. We are going to discuss business ethics, corporate governance, and business law. We are in module 15. This is the domain of comparison of English law with alternative legal system. Today we will discuss the purpose of the civil and criminal law, the source of English law, customs, case law, statute, European law, and other sources, the distinction between the common law and equity, the system of judicial precedent. The purpose of civil and criminal law, if we see here, what is law? Law is a system of rules that are enforced through social institution to govern behavior. So, law is a system of rules that are enforced through social institutions to govern behavior. Civil law deals with the dispute between private parties or negligent act that cause harm to others. So, civil law deals with disputes between private parties or negligent act that cause harm to others. And criminal law, one of the two both categories of law, deals with act of internal harm to individual, but which in a larger sense are offense against us all. So it is the criminal law. So there are the part of law is civil law and criminal law. Civil law and criminal law are two broad of separate entities of law with separate set of laws and punishments. So civil law that deals with the non-criminal things, and criminal law deals with the regulation of enforcement of rights, setting acceptable limit of conduct in society. So the historical interaction of equity and the common law led to the development of the first source of law, case law, which is based upon the system of judicial precedent. The second source of legislation, which is law created by Parliament. So if we see here, look, law, the statutory law, common law, and here the statutory is divided in the criminal or crime against society law. It is the some are internal, some may result in the criminal or civil action. Here, if you see the common law, also the civil laws of the individual organization, as can be separated two types. One is the torts and one is the contract of warranty. Here, tort also come here, internal, international, and strict liability, and it may cause in the civil action. So if you see the civil law, it is the parties involved is private. Look here, look, civil and criminal, if we separate both. So parties involved with the civil law, private plaintiff versus a private defendant, and a criminal is the government versus the private defendant. And standards of proof, prevalence of the evidence, and criminal law beyond beyond a reasonable doubt, and burden or proof is raised with the plaintiff, and criminal raised with the government. So examples: breach of contract, personal injury, etc. is the civil law, and criminal law is that means murder someone, burglary, etc. And penalties for civil law, financial compensation, other things, and criminal, that's mean fine, others. Civil law deals with the dispute between the individual, organization, or between the two, in which compensation is awarded to the victim. And criminal law is the body of law that deals with the criminal and the legal punishment of criminal offense. So it is the difference between here segregating is defined to a definition, purpose, cause filled by, decision, a standard of proof, burden of proof, and types of punishment, example, appeal, jury option, commencement of proceeding. So you have to read all thing, download this sheet from my Google Drive and read it. Okay, so now the source of English law, customs, case law, statute, European law, and others. So source of English law, look here. That means the principal source of English law are legislation, common law, European Union law, and the European Convention of Human Rights. There are no single series of document that contains the whole of the law of the English. The source is maybe the source. We can say that customs, common law, equity, European law, other source, etc. is the source of English law. So equity is an historical source of law. The others are current source of law. So look here, look this picture. Here common law, the legal system of the England and Wales is a common law one. So the decision of the senior appellate court become part of the law. So the legislation, it is the law that created by the legislature, the most important piece of legislation act as act of parliament. So European Union law, the UK is a member state of the European Union, which means that a law takes the precedent over the UK. But now UK is not with the European Union. So the European Union Convention of the Human Rights as a member state of the civil of the European, the UK, the signatory of the European Convention of Human Rights. So how UK law is classified? So look here, law, international law, national law. National law is two types, public and private and civil, and public's constitutional law, administrative law, criminal law. And private or civil law is the contract, tort, family law, company law, and many others. So it is the UK law classification. You look the picture here. So a criminal law, which is the branch of the public law, defense of the boundaries of acceptable conduct. A person who breaks the criminal law is, regardless of the having commitment in the offense against society as a whole. And equity. So common law is known as the case law, is developed with just, court, and similar tribunal is the common law. So look here, the equity, the branch of English law, which is developed hundreds of years ago when litigants would go to king and compliance with the hearts of the inflexible rules. Common law, which prevented justice from prevailing. Equity is based on a judicial assessment of peers and opposed to the strict, the rigid rules of the common law. So use of the word equity as body of rules administered by court of equity, justice and fairness, stakeholders, opportunities share in a limited value of the property over the above, equitable rights of claims such as the equity of the redemption, etc. So common law and equity, if you see here the common law is rigid and flexible. It is flexible. It is bounded by rules of bureaucracy. And equity is based on the fairness, consideration, and the moral code. It is flexible. This is the difference between common and equity law. So if you see the system of judicial precedent, judicial decision. That means 3 stages here. So number 1, examine all the fact to determine the material and consider the law, apply the law. It is the 3 stages. A precedent is a previous court decision which another court is bound to follow by deciding a subsequent case in the same way. If we see the element of judicial precedent is element of judicial precedent, 3 element is the reporting, rules and classification. If you see the reports, there must be adequate and reliable reports for the earlier decisions, and rules, there must be rules for extracting a legal principle from a previous set of facts and applying it to current facts. And classification, if we see precedents must be classified into this, they are as binding those which are merely perceives. In order to judicial precedent, the previous consistency in law, the ratio decedent must be identified, and also ratio, if you see the arbiter dictator or words in a judgment which are said by the law. If you see the right side here, look, there's the judgment in a case may be several pages long, not all this information related to the material fact. This is known as arbiter dictums, or the things said by the way. Okay, so the House of Lords, the Supreme Court of the United Kingdom, the United until October 9, the House of Lords had 2 roles. Firstly, as part of the process of creating legislation, and secondary, the final appeal code in the English code structure. Structure that in England and Wales comprise the following: a magistrate code and country code, crown code, high court, Queen's bench, family and charity, court of appeal, and House of Lords, and the Supreme Court of the United Kingdom. Civil code is, look here, this is the House of Lords, the Supreme Court, and below is the Court of Appeal, and it's below the Employment Tribunal, Employment Appellate Tribunal, and High Court. It is the 3 types: QBD, Family Charity, Divisional Court, and also Magistrate Court. Crown Court goes up to the Court of Appeal, and Country Court, also Restricted Practice Court, and Private Civil, European Just Court, etc. So it is the straight line, arrow is the appeal, and the dot line is the appeal by the way of case stated. So the criminal court structure in England and Wales is the following: Magistrate Court, Crown Court, Divisional Court of QVD, Court of Appeal, House of Lords is the Supreme Court of the United Kingdom. Diagram have set the code English criminal code structure here. The English criminal code structure is House of Lords. House of Lords, that is the Supreme Court of the United Kingdom. Court of Appeal. So first, Magistrate Court, then the Crown Court, then Divisional Court of Queen's Bench, then Court of Appeal, Criminal Division, and House of Lords, the Supreme Court of the United Kingdom. So here, this is the straight line of the appeal. Dot, small dot is appellate to the way of the case of study, and the big dot is commercial from the magistrate court. So it is the structure of Supreme Court of the United Kingdom. So today we are going to finish this class, but I think it is just summary we discussed. Please download my sheet and read it. So here today we discuss the purpose of the civil and criminal law, the source of English law, the distinction between the common law and equity law, the system of judicial precedent. So it's all today. Inshallah, we'll meet with you with my next module 16, within the same domain. So till then, take care. Allah Hafiz.